The first case on the docket for Tuesday, February 1st, 2022 is Appeal Number 122682, State of Kansas versus Ty R. Zeiner, Marion County. Briefs both sides. Your Honor, we are ready to proceed.
Please the court, Kelly Trussell appearing and ready for argument on behalf of the appellant Ty Zeiner.
May it please the court, the state appears by Assistant Solicitor General Natalie Chalmers. I'm present and ready for argument.
We will now proceed with our argument. Ms. Trussell.
Madam Chief Justice, may it please the court, I would like to reserve 3 minutes of my time for rebuttal. I was told that the court wished to have a short recitation of the facts for this case, and this is a DUI case. There was a dinner and some beers at that dinner with my client. He then proceeded to drive from Strong City to his home in Marion County. And then got tired, pulled along the side of a gravel road on his way home. And a few hours later, a deputy checked on him. The car was not running at that time. The radio and headlights were on. There was an odor of alcohol, so field sobriety tests were done. Later, there's some insufficient breath samples that were provided. And he was convicted in a jury trial of DUI. We did appeal that to the Court of Appeals. The first conviction has been reversed because of the insufficient breath samples being the reliance on that conviction. The second alternative conviction was upheld in a 2-to-1 decision. And our jury instruction error argument, it was found that there was a jury instruction error, but it was to be held harmless. We petitioned this court for review. The state also petitioned for review, and they are asking for this court to relook at the definitions that this court has provided as to operating and driving. First, I will address the insufficient evidence to support Mr. Zeiner's conviction, and then I plan to address the jury instruction error. And finally, I will address the state's issue of broadening the definition of driving. That may be overly ambitious for my time, but I will do my best. Under Kansas law, it is not illegal to drink alcohol and then drive a car. It is only illegal when the defendant consumes alcohol that makes him incapable of safely driving. A DUI conviction requires the state to prove that the defendant was driving or attempting to drive the vehicle while he was under the influence to a degree that rendered him unsafe to do so. These are simultaneous event elements, and that is the problem with the evidence in this case. How intoxicated was Mr. Zeiner when he drove the vehicle to the gravel road that night? We simply don't know.
Do we know how long it was from when he pulled the car over to go to sleep or for whatever reason, and when he was first observed at around 3:30 a.m.? Is there any evidence as to how long he was there prior to being observed?
It is vague. We do know the timeline of about when he was in Strong City. That timeline runs to probably around 10 o'clock in the evening. And then he proceeded to drive. And he parked about 3 miles from home, right. So he got pretty far into that drive. There was a witness who drove past him. The timeline on that is sometime after midnight. And then he went home, and his father called the sheriff's office, and the deputy checked on him about 3:30, 3:15 in the morning. So the deputy did testify. He had no idea how long the car had been there, but that it could have been hours.
Why isn't it a reasonable inference for a jury to conclude that your client was driving while intoxicated?
Well, he very well could have been driving while intoxicated, but it's that level of intoxication that the state needs to prove. He needs to be intoxicated to the point that it's unsafe for him to drive.
And that was found by the jury, correct? As at the point in time at which the officer came to the vehicle. That was an element of the crime that was proved to the jury, right?
The element that was proved to the jury was that he certainly had a level of intoxication at the time that he encountered the deputy.
That made it unsafe for him to drive.
That is right.
What your argument is that, hey, he wasn't driving at that point in time.
Absolutely.
So that level of intoxication could have been achieved post-drive.
It certainly could have.
My question is, why isn't it, so you could go either way, and I get that there could be a reasonable inference either way, but since we're on a sufficiency review, viewing the evidence in the light most favorable to the state, why isn't it a reasonable inference for a juror to conclude that, yeah, he did drive while he was intoxicated?
The reason that it's not a reasonable inference to get all the way back to the point in time where he parked the vehicle is because there's multiple issues in between that time that the jury has to make inferences on. And so going all the way forward to when he encountered the deputy, he certainly had some level of intoxication, and that was proven. But we don't know at what point in time he reached that level of intoxication,
Right.
and he was not driving. So to automatically take that evidence and rewind it back several hours to the point in time when he parked the vehicle, there was no evidence to support any of that inference because the jury was given no information as to what to do with that.
What if it was 5 minutes?
I think then we have a different problem. I think we aren't here.
Right, so I guess that's the question then. Like, how long is too long to make that no longer be a reasonable inference?
Well, I think this case is also further complicated in this reasonable inference analysis when there is evidence of alcohol consumption in the vehicle from the point in time of him parking to the point in time of the deputy encountering him. And so it's not like he parked the car, did not have access to alcohol, and then there's this evidence of intoxication with the
I
deputy.
presume you fully presented that defense to the jury, and the jury just didn't buy it.
Yes, I did not try this case, but yes, there was the evidence of the alcohol inside the vehicle came from the deputy because the defendant did not testify in this trial. And so we don't know when he consumed that alcohol. That evidence
But just
did not come
clarifying,
in.
that the defense in this case has been consistent throughout, at least that's how I read it.
Yes.
In other words, the defense has been, hey, he consumed alcohol after he parked the car.
That is one theory. The other theory is what happens with intoxication, and that was never presented to the jury either. When you have these blood alcohol concentrations and when you have intoxication levels, the levels continue to rise even after alcohol has ceased being consumed. But that was never presented to the jury, so they didn't know what to do with that, with those facts. I mean, they had no facts to base any inferences on. They would have just had to make sheer guesses. And making one guess is an inference. Making an inference and then having to make another inference in order to get to that third inference, that's where we've got a problem with the sufficiency of this evidence, because that is improper inference stacking.
Was there any, any observation of his operation? By that, I mean driving the vehicle that night by anyone?
No.
That testified at trial, that law enforcement ascertained that, hey, he was driving? There was none of that?
Yes, you're right. There was no witness whatsoever that ever saw him drive that vehicle that night, and there was no evidence that the way that he had parked the vehicle.
So what is the evidence that he's incapable of safely operating his motor vehicle, if there's no evidence to that?
There was none.
There was none?
There was
That's
none.
what I thought.
Well, let me clarify a little bit, because I thought in our earlier exchange, you conceded that the state presented evidence of a level of intoxication that would render him unable to drive. And
Certainly.
the jury found that.
Well,
At the time that the officer arrived.
right, at the time that the officer arrived.
So there is evidence that at the time the officer arrived, if he had started his car and tried to drive at that point, he would have been lawfully convicted of driving under the influence.
Absolutely. And that's where the problem in this case is. We have evidence of driving and we have evidence of intoxication, but they don't happen simultaneously. And then there's this gap in time. And, you know, if it was a very short amount of time that had occurred from him parking the vehicle until these tests were done, and when Deputy Starkey came upon him, then that is a very proper inference to make. But when you have this gap in time and all of this other evidence in between, and the jury had no facts from evidence to rely on any inferences as to his level of intoxication at the time that the deputy ran the test, to correlate that and rewind it back to the time that he actually drove. That's where the insufficiency of this evidence is.
Are you saying that that's necessarily inference stacking and that there's no other way they could come to that conclusion?
Well, it's interesting because every time this case has been presented, there's been a different theory as to how we could get to a conviction. And I think that, to me, raises red flags. We have one theory of the way that the jury could have gone about it. We go to the Court of Appeals, and that opinion had a theory. The dissent even had a theory. And so if we have all these, if we always have to have a theory of how this occurred, then it automatically draws suspicion to the inferences that were made. And then we have to look, was it inference upon inference? Because that part is improper.
But to Justice Stiegel's point, I believe, and you can correct me if I'm wrong, we're reading this evidence in a light most favorable to the state. So don't you have to prove that it's necessarily inference stacking? If we can find inferences from various pieces of evidence that the jury could have made, then we have to go with that, don't we?
Do. And that's where there's gaps with the facts in order to make those inferences that do have to be decided in order to get to the conviction. For example, in the inference, several inferences that a jury would have to make in order to get to a conviction would be, one, how long was Mr. Zeiner parked along the roadside? And two, how intoxicated was he when he parked? And three, when did he stop drinking? I mean, we can make a list, but those are all the things that we don't have any evidence in the record for. And so all of those are inferences that they have to make in order, in the first place, to take the evidence that happened with Deputy Starkey and take it to the point in time when he was actually driving.
Isn't the only one of those that matters is how intoxicated was he when he parked the car?
Absolutely.
That's the only one that matters.
Absolutely. Because it absolutely does not matter how intoxicated he was when he was with Deputy Starkey. It only mattered how intoxicated was he.
Really only one inference that the jury has to draw.
How did they get there without, in one step?
Is it sufficient or not? And to go the opposite of my 5-minute example, take it the opposite extreme, it would clearly be improper, I think we could say, for a jury to say, if you were found intoxicated 24 hours after known driving, like that would be an improper inference. That doesn't make any sense to say, well, just because you're intoxicated 24 hours after we know you drove, you must have been intoxicated when you drove.
Right.
But we're somewhere in between those two
It's
things.
somewhere in between that with zero evidence for the
Can I move you
facts.
real quick to the jury instruction
Yes,
issue
so-
and just ask straight away, isn't your position hamstrung to some degree by the fact that the instruction just mirrors the statute?
No, I don't think so, because the definition needed to happen in this case, that operate means drive, and that those two terms are synonymous. And the reason why, I mean, first, we've got all this evidence issues in the first place as to when was he operating and when wasn't he, that the jury had to get through in instructions, and there was some confusion with that. But then when the testimony came in with Deputy Starkey, he testified, the question was, because he had said that when he encountered him, the headlights were on and the radio was playing. Counsel asked, so does that mean he was operating the car? Or driving the car, excuse me, because that part's important. Was he driving the car at that point? And the deputy says, no, but he was operating it. So we really did need to have the Darrow definition that said operating and driving are synonymous. They're not two different things.
I have one fact question I'd like to ask. As I understand the record, it established that there was one bottle of unopened beer in the car, one bottle of open beer, and then several bottle caps of the same brand of beer. Was there any evidence of whether or not the deputies searched the area around the car for empty bottles?
He did not search. He actually testified that he did not search in the area around for the beer bottles. So we have the caps, we don't have the bottles, and there was zero search as to where those bottles were located. Right? If there's nothing else.
Just to clarify one fact also, and I'm sure that I have this, but just as you're making your argument, Strong City is how many hours away, if you're driving the speed limit, from where he was found?
So sorry you asked that question because I have no idea, honestly, how far it is.
Okay.
I'm sure it's in the brief somewhere, but
Okay.
I honestly, off the top of my head, do not know. I hate to admit it, even point it out on a map, so.
There's evidence that he left the bar at 10 p.m., and then the deputy comes upon him at 3 p.m.
3
a.m.
a.m. Yes, 3 a.m.
So 5 hours, but we don't know how far the drive was.
Not know.
Okay.
To answer your question, Justice Sandwich, I don't have an answer either. I don't remember anything in the record telling us one way or the other. I think this is a town where everyone knows where everything is, but it wasn't in the record. I did Google it at one point when I prepared my brief. I think it's like a few hours. It's not 5 hours, but I could not tell you exactly what it is. But Google was the only way that I could do that. The deputy did say he took a strange route from Strong City to his house, that it was not a direct route. So presumably he was taking back roads, which is something that intoxicated people often do to avoid detection. I would, unless there are questions on sufficient evidence, which I kind of expect, I would rather stand on the brief and focus on the jury instruction issue, but if you have questions.
Well, what
yeah.
is your theory? There's no evidence that he was incapable of safely operating a motor vehicle.
He pulled over on the side of the road and passed out. I think that's evidence that he was incapable
Well,
of safely.
how do you know he passed out? He pulled over, his car was properly pulled over, was it? It wasn't like to an angle off in a ditch somewhere. Properly, I think that was the testimony or the evidence was that.
The testimony was that it
was on the
wasn't-
shoulder of the road, properly parked. What other evidence do you have that anyone witnessed that he was incapable of safely operating his motor vehicle?
You have him have the first passerby come at, we don't exactly know, the 911 call was about 3:15 in the morning.
Passerby that didn't see him driving.
But the passerby saw him with the car running. The car was running at that point. When the deputy came, the car was not running. So he did something between the time the car was running and not running in 30-degree weather where he decides to just pass out 3 miles from his house. I think it's a reasonable inference for the jury to make that he passed out not because he was tired, but because he was too intoxicated to make it safely to his house. And then I did argue this to the Court of Appeals, and I do admit that it's a bit of a stretch, but the other theory we have here is attempt. The second he came and the officer came, he repeatedly, at least 6 times, asked to drive that vehicle. He kept trying to drive that vehicle, even when we, and defense counsel admits, knows he was unsafe to drive. That was not, however, argued to the jury, so probably was not a theory they relied on. And I'm not sure if that goes far enough for attempt, but it is plausible, potentially. As to the jury instruction issue, the state's first contention is that we would like Areens to mean what it said, and I don't know that I'm pronouncing that case correctly, so if I need to pronounce it a different way, please let me know. Areens said that the legislators said when they changed, Areens said when the legislator amended drive to operate, they meant an actual change. They didn't just mean driving the vehicle. So things like turning the engine on and having the engine running and having the radio running and the headlights, in most other states, that would be a DUI. It's not in our state, and it's not in our state because this court has defined operating as driving, despite what we believe is clear legislative intent, that the legislator wants operating to be broader than just actually driving or attempting to drive.
So given that, counsel, I presume it goes without saying that the state's view is that what you just articulated is a reasonable interpretation of the statute.
Yes.
Given that, if you don't convince us, doesn't that necessarily mean that this instruction is confusing?
The instruction that doesn't define driving and operating, or operating as driving, I think the requested instruction was incomplete, and I've argued that too, and that's a reason
Let's
not
just
to
stick
give
with
it.
the instruction
Okay.
that was given, which says operate or attempt to operate. And that's the statutory language. And your view is that it's a reasonable interpretation of that language to think that what that means is not drive, but have the car running, have the radio on, et cetera. And so if that's a reasonable interpretation of that language, I fail to see how that cannot be confusing to a jury when our case law is that it requires driving.
I think in this particular case, it probably would have been better to give
It
that.
just seems to me the
as
state's put all its eggs in that basket. And if you don't prevail on the basket you picked,
Then we might
this
have
is a
an-
confusing instruction.
I don't know that it's confusing instruction in every case, but in this particular case, when there is a fight about what operate means in driving. Here, though, defense counsel did say operate means driving, and no one contested that. The only evidence that contested that was actually brought about by defense counsel's questioning, or this would not have been an issue in the case at all. Well, potentially would not have been an issue until counsel argued that operate could have been interpreted by a reasonable jury as having the engine on. So yes, I would essentially concede that the instructions here probably could have been supplemented. I don't know that I like the defense's requested instruction, which did not put in the part about attempting to operate does not require movement of the car, which is so we think it's an incomplete instruction, and that's the reason it shouldn't have been given.
Let me ask a follow-up question. I don't know, for some reason, I've always pronounced it errands, but,
Okay.
so I'll say errands. Errands was decided in 2012, right?
Yes.
A decade ago.
Yes.
If that's not what the legislature intended, why don't they change it?
They could certainly change it. I think errands was correctly decided, though. You came out with the correct rule in errands, and it wasn't until Darrow that the court came back and ignored all the legislative intent language in errands and the language that was favorable to the state in errands, and then said, no, operate must mean drive. And yes, again, the legislator can change things, and the DUI statutes have been tinkered with. I don't know if that 16.7 has been tinkered with, but there's certainly quite a bit of DUI laws that have been tinkered with since then. So.
But so is Darrow 2016?
Yes, 2016. Yes. But also, if the legislator, in reaction to Fish, did try and fix it, and this court, according to Aaron's anyway, seems to have blatantly ignored that fix, maybe the legislator's just like, we don't know how to do it. I mean, how else do we take drive? We use the word operate, and what else could we do?
Add a
is another.
definition.
That is certainly something that they could do. They do, interestingly enough, have a definition for drive itself, which is just essentially possession of the car. So that ties back into operate means, or driving even means just possessing the car, or not possessing, I'm sorry, having control of the car.
Where is that? Where is that definition?
I would have it if I would get my brief. It is in the supplemental brief.
It's not part of 81567.
No, it's not part of 81567. But then I still think there's sufficient evidence that the worst that happens here is potentially a retrial based with the proper jury instruction. But I do think the error in this case was harmless based on the evidence. There was no, again, defense counsel told the jury that operate means drive, so at least according to this case, the way the jury would have understood it would operate means drive. The evidence here, I think, was actually pretty strong for a DUI intoxication. And just as some points, the defendant himself is on tape in this case. He's on tape in this case where he admits to driving the vehicle, he admits to having a few beers. He does not say anything about, gee, I got really tired, and so I stopped and decided to slam a few beers back and then pass out, and that's why my blood alcohol content is so high. He doesn't say that. That is mere speculation. Even the dissent in this case talks about how that particular defense that was the defense at trial is speculation. I don't think a reasonable jury would be likely to go without hearing some kind of evidence from the defense.
Given that the officer testified that the defendant was not driving but was operating the vehicle, isn't there a possibility, a reasonable possibility, that a juror, even one juror, could have thought, yeah, he wasn't driving, but I heard the officer testify he was operating, and that's what this instruction says, so I'm going to find him guilty?
I think that that particular evidence is difficult for the state. I will agree with that. I do think that the defense counsel himself saying operate means drive, the prosecutor not refuting that at all, would suggest that the defense counsel, who is the legal scholar, is apt to be right about that instruction, and so a jury would probably
Do
defer
you
to
think that
that.
it's not reasonable to think that a juror would believe a police officer over a defense counsel?
I think that's a hard position for me to take. I do, however, think that, well, that this operating, and that's why we're making the argument we're making, is that operate should include having the engine on, having the headlights running, having the radio on, turning the engine off, which is what he at least had to do to have it go from running to not running between the time of the 911 call and the officer showing up. And for those reasons, we would ask that the conviction in this case be affirmed, or in the alternative, reversed and remanded for a new trial with proper jury instructions. Thank you.
Russell, you reserve 3 minutes.
To address the statute that, for the definition that was just brought up, it's 8-1416, but that definition does not define drive, it defines driver. And there is a distinction, and we did brief that as to what that distinction means between defining driver and defining drive. The State v. Aaron's case, I don't think stands out from the precedent that this court, I think each of these cases that the court has addressed what does operate mean and what is required in order to get to operate. I think it's been consistent throughout every case since 1980 in this court. And even in State v. Aaron's, one of the statements in that opinion, they said the term operate and the phrase attempt to operate merely describe the factual circumstances in which a material element, i.e. driving, may be proven. So I don't even think that one stands out as anything different than what this court has always intended operate to be, which would be driving or attempting to drive for the attempt to operate. As to the likelihood of him pulling over on the side of the road that night, there was evidence presented at trial from the deputy. Deputy Starkey was actually a friend of Mr. Zeiner. It's a small community. Mr. Zeiner is an owner and operator of a funeral home. And it was not unlike Mr. Zeiner to be out all hours of the night and driving on the road. and being very tired. During his testimony, he did concede that he did not find it to be unusual to find Mr. Zeiner parked along the side of the road asleep. And so I don't know that there's a lot of weight to put onto that fact as to the unusualness of this event of him pulling over on the side of the road. As to this legislative change, or the legislature not changing what operating means in the statute, I go back to my statement that since 1980, the court has consistently stated, this court has consistently stated, that operating a vehicle is driving it. And examples of that consistent definition are State v. Fish, Kendall, Ahrens, and Darrow. And if the legislature disagreed with any of those opinions, then the legislature would address it. They've had multiple amendments to that statute in all of that time and have never taken it upon them to do that. The state cannot support a DUI conviction on what a driver may have done. A conviction can only be supported on what a defendant actually did. With no evidence that Mr. Zeiner's driving was impaired driving, he cannot be convicted of the DUI. Thank you.
Thank you to both counsel for your arguments. The court will take this matter under advisement.